Hello, everybody. I can't see anyone, so I feel like I am speaking into the air, but welcome to this Garden Court webinar, which, as you'll see from the title page, is about damages for visa revocation and maladministration by the Home Office. I'll go in a little bit by way of introduction into what we're going to cover, but before then, as I'm sure you're all now very well familiar, there are some basic aspects of how this webinar will be conducted that I just need to talk to you about first. First and foremost, it will be recorded and it may be used for marketing purposes. As you will have expected, everybody has been muted and you would only unmute if you're going to make a contribution. Experience shows that contributions are much better if they're put into the chat, and then we can deal with any questions or comments or feedback towards the end. So if there are any technical difficulties, there is some guidance on that in the chat window. If we can help with that, we will. So we've got 3 contributions today. My name's Stephanie Harrison, as well as introducing this seminar, which we think is an important seminar. We're going to have contributions from Greg O'Keeley and David Selwood. Greg is going to speak about the impact of a series of government policies that have resulted in unlawful revocation of visas in a number of different categories, whether it's tier 1 students or others, and is going to focus on the common law claims that can be made for the consequential loss and damage, which, as I'm sure are all very familiar from our clients, can be very substantial. So Greg will look at the common law remedies. David will then follow on and consider the Human Rights Act claims that can be made and the claims for damages. And then I'll finish up with some outline on key issues on practice and procedure. So having said that, I'm going to ask Greg to start first with his paper.
Good morning, everyone. So what I want to talk about today is, as Stephanie suggested, ways we can use the common law to look for remedies in the era of the hostile environment. What I'm going to do is talk a little bit about the context of that and why I've been thinking about that, and the torts that are potentially available. Some of them are old and some of them are more recent. And the reason that I've spent a lot of time thinking about this is because over the last couple of years, I spent a lot of time working on the cases of people who've had their leave curtailed, generally in relation to cases. So, for example, people who are alleged to have cheated in English language tests, but also in relation to people who have been alleged to have made fraudulent HMRC claims. So I want to talk a little bit about the context, first of all, in the hostile environment, the way these things kind of interact together. So since 2012, the precariousness of life for migrants has changed significantly in this country. And the effect of the 2014 and 2016 Acts is that a person who is in this country without leave can't work, can't study, can't rent, can't open a bank account, and can't drive. And those provisions obviously have a massive impact on the lives of our clients, but they also interact in a really problematic way with the fact that a lot of rights of appeal were taken away at the same time. So the 2014 Act, as most of you will be aware, had the effect that most immigration decisions, including refusals and curtailments, no longer carry a right of appeal. And since then, the government has liberally used curtailment powers and refused leave on a virtually blanket basis in certain categories of cases. So TOIEC cases are the classic example. If you were on the Home Office list of people who had cheated in an English language test, you were getting your leave to remain curtailed. Similar approaches have been taken in other kinds of cases, including the 3225 cases, which are HMRC have discrepancies from what you've told the Home Office you earn in the context of tier 1 applications. And there's often minimal or no consideration of individual factors in those cases. And the effect of this is that a lot of people who have never previously found themselves at the immigration fund now have done so. So in addition to the people we would have found in this position before, you can have somebody who was a successful businessman running a really successful business on a Monday, and on a Tuesday they're an illegal immigrant with no right to work, and their very presence in the country is unlawful. Or you can have somebody who was a PhD student having successfully completed a master's in the middle of a PhD on a Tuesday, and then on a Wednesday they are here unlawfully, have law fees and no right to work anymore. So these people need a remedy. So in a lot of these cases, particularly the kind of broad brush curtailment cases like TOIEC and 3225 cases, it took quite a lot of litigation to establish that these people had any kind of remedy at all in respect of their entitlement to remain. And that's not the focus today, but it is relevant, because by many years, in many cases, it will have taken, by the time it's established that the original decision is unlawful. So for example, your student shouldn't have had their leave to remain curtailed when they're in the middle of their PhD, or your person who was running a business shouldn't have had that taken away from them. They will have spent 4 or 5 years exposed to the hostile environment. So, somebody's lost a place at university, can potentially have lost thousands of pounds, sometimes tens of thousands of pounds of university fees, lost a job, lost substantial earnings, accrued debts, suffered injury to their mental health, which could manifest later as a personal injury claim, lost thousands of pounds in legal fees. So when I've been meeting people in the first tier tribunal, when we've managed to successfully get them a right of appeal and successfully overturn the original decision, or bring about a situation in which they've got a grant of leave to remain, the reality is that's just not enough. If you've been left without leave to remain for 4 or 5 years, the consequences of that are enormous. So in that context, we've just been looking to try and find a way of giving those people a full remedy. So what are the options? The main options are false imprisonment, misfeasance, negligence, breaches of the DPA, the new one and the old one, Frankovich, team damages. Now, David's going to speak after me about the Human Rights Act 1998 damages in a little bit more detail, and he's going to look at the issue of the Ombudsman and the ex gratia scheme as well. Well, the first thing to look at in the classic is false imprisonment. So it's trite law now that where a public law error bears on the decision to detain, that would affect the lawfulness of detention. Now, the Secretary of State has argued, in some cases with some success, that an entirely separate decision may not to vitiate the lawfulness of detention, and there was the Draga line of authority in that. The Supreme Court in DN Rwanda recently emphatically rejected the argument that an unlawful underlying immigration decision could be separated from the decision to detain, and there's a clear statement of that on the slide from Lord Kerr. So if your client was detained in reliance on an unlawful curtailment or a refusal decision, that may well render the detention unlawful if it bore on and was relevant to the decision to detain. So, for example, your client has had their visa curtailed on an entirely unlawful basis. So, for example, their visa was curtailed in false and that they had no opportunity to respond to. And 3 or 4 months down the line, that person is detained for removal. Well, then you can challenge that detention on the basis that it was unlawful on this kind of DN Rwanda Lumba basis. Detention is one of the cleanest ways you can challenge these kinds of public law errors, and it's one of the advantage of challenging these kinds of decisions by means of detention. It's almost like a collateral challenge. I mean, really what you're complaining about is what was done in the first place, particularly if you're only detained for a very short period. But you can build in the surrounding treatment in terms of the curtailment by way of aggravated damages and obtain damages for the way you were treated in that way. the other thing you can remember in respect to detention is personal injury, although the deadline for personal injury cases is 3 years, although that can be extended unlike the detention deadline. Misfeasance is the second tort I wanted to talk about. Misfeasance, it's a notoriously difficult tort to make out because it requires bad faith. The Home Office fights these claims ruthlessly. I've heard that the Home Office, if there is a finding of bad faith, there has to be an internal record of that that's taken quite seriously. They do really fight misfeasance cases. The test is a high one. It's set out in 3 rivers, but clarified in Noosa, where it was, as is put by Lord Justice Thomas. The tort will be made out where the defendant acts in the knowledge of or with reckless indifference to the illegality of their actions, or in the knowledge of or with reckless indifference to the probability of causing injury. If your client's leave was curtailed in circumstances where the Home Office knew there's a real possibility the decision was unlawful and knew that the decision would harm your client, you have a misfeasance case. So a straightforward example of a misfeasance claim I'm involved in is somebody who was expected to be in a marriage of convenience. The Home Office interviewed her husband separately and lied to each of them about what the other had said, and then falsified an interview record. Now that is the classic misfeasance deliberate action to which causes harm. That's absolutely clear that that's bad faith. But what about if an immigration officer has information about someone that they know is probably, there's a strong possibility that it's wrong, and they act on it anyway? In that kind of a situation, there's a strong argument, in my view, that you can make out the reckless indifference to legality approach to misfeasance. You should be aware that there's an issue with misfeasance. It may not be necessary to find the individual in question for the purposes of the claim. That's something you need to do via disclosure if possible. Negligence at the moment is a really interesting area. Traditionally, it hasn't been possible to bring claims against public authorities, and especially the Home Office, for negligence in respect of actions carried out pursuant to a statutory discretion. The leading case on this is Ahmed, and that is a case where there are major delays in granting leave to a group of Iraqi Kurds. So there were delays in processing their applications, and those applications, they were wrongly denied the benefit of the relevant published policy as a result. And the case of W against the Home Office. And in W against the Home Office, a person was unlawfully detained as a result of the fact that somebody else's interview record was put on their file, which led the Home Office to doubt their identity. Now, the interesting thing about W and the Home Office, in terms of what it says about the problems of imposing a duty of care on the Home Office in that kind of scenario, is that W against the Home Office will be plainly unlawful now on a pure lumbar basis, because there's no question at all that the putting of the wrong interview record into this individual's file, which resulted in his detention, would have been a public law error bearing on the decision to detain. Now, the point about the Home Office against Mohammed and that line of authority is that you can't have a claim for negligence. There will be no duty of care in circumstances where the state body or the local authority or the Home Office is carrying out actions pursuant to a statutory discretion. However, recent decisions suggest it may now be possible to formulate a duty of care in certain circumstances. So, for example, where the conduct would be tortious if it was committed by a private body. And there have been a large number of major landmark negligence decisions in the past number of years from the Supreme Court that suggest that this tort is moving. This year, however, the Court of Appeal in the case of Hewson held that it was arguable that there was a duty of care between the Home Office and a person to whom it had undertaken that a BRP would be provided. So that's the classic exercise of statutory discretion, the Home Office performing its statutory function. And because of the fact that the Home BRP within a certain period, it was considered an assumption of responsibility, and so a duty of care will be undertaken. So it does suggest that the courts will be willing to look at the factual circumstances in deciding whether or not a duty of care is made out. And in my view, it's equally arguable that where the Home Office itself has created a danger, e.g. by proactively curtailing a person's leave and exposing them to the hostile environment, that will be a basis for finding a duty of care. And there needs to be a case on that. It needs to be dealt with. And if you look for comparison at the approach in pool, and what would happen if this action was committed by a private body, imagine the Home Office had outsourced the question of enforcement of, for example, curtailment for fraud to a private body, and they curtailed people's leave without any adequate investigation of their whether they were responsible for the conduct they're accused of. In my view, there's no doubt at all that that would be negligent. So I really think that there's a case there that we can start. Negligence looks like it may well be something that we can use in this context more often. The Data Protection Act is also one to be aware of. If it's possible to obtain an award of damages if data is processed in a manner inconsistent with the data processing principles. One thing that it's important to remember is whether your client's case falls under the old DPA regime or the new DPA regime. Even if you're out of the scope for the 1998 Act, you can still bring a claim under it by virtue of the transitional provisions. However, note in the latest Act, the wider exemptions in paragraph 4 of Schedule 2 in respect to the processing of information for the maintenance of an effective control. Now, there's a case being brought to the Court of Appeal by Open Rights Group in respect of the extent of that limitation. It shouldn't in any event allow the processing of information in a manner that's unfair. There are only certain parts of the principles that are exempted on a fair reading of the provisions of paragraph 4. And the extent to which that those exemptions apply is still being litigated. The other option is frank damages. You will see in cases where your client has an EU law right and that right is breached, you can bring a claim for damages in circumstances where the right breach involves a rule that was intended to confer rights on individuals, and the breach is sufficiently serious, and there must be a causal link between the breach and the damage caused. And there are a number of cases dealing with that, and I think the clearest for setting out the correct approach is set out in Santos, which is a decision of Mrs. Justice Lang. And now that is all I wanted to say on the introduction and the overview, and I'm going to pass over now to David Selwood.
Thank you very much, Greg. I'm just going to try and share my slides with you. Can you see them?
Yes.
Great. So I'm going to talk for about 20 minutes about human rights damages and whether there are any alternatives to that process, either under the Parliamentary Ombudsman, a complaint to him or her, or a payment through the Home Office ex gratia scheme. I'm going to really cut it up into 4 bits. The first is whether or not there is an engagement with the European Convention on Human Rights in the cases that we are discussing, and if so, on what basis. The second is how to claim damages under the Human Rights Act for ECHR violations. The third is looking at determining the thorny issue of quantum. And finally, a brief consideration of the Ombudsman and the ex gratia scheme. So first, I think we need to look at and consider what decision is being challenged. And for our purposes, as Greg has already said, I think they're more likely than not to fall into one of 3 categories. The first is going to be where there's a curtailment of leave to enter or remain. For example, as Greg said, where there is an accusation of fraud or other grounds under the immigration rules. The second is when there is a delay, almost always severe, in determining an outstanding application for further leave to enter or remain, or indefinite leave to remain, or even citizenship. And the third is when there is a delay in providing documentation confirming immigration status. And that's normally a biometric residence permit. And often that can happen where, for example, somebody has an outstanding deportation appeal, or there are oversights or complications during the process of issuing a grant of leave to remain. I think the key here is to stress it's not so much the nature of the decision that you're looking at or lack of decision, but really the adverse impact that that has had on your client. And I think the most obvious of those have to be the prohibition on employment or study, either because your client has no leave to enter or remain, or because in practice they struggle to show that they have continued leave and rights under Section 3C, and or the exposure of them to the hostile environment, which Greg has already mentioned. There you have an inability to rent, to drive, to open or access bank accounts, have recourse to public funds, access secondary NHS care, etc., etc. So that impact is likely to be, in many cases, particularly for individuals with families, quite substantial and severe. When is the ECHR engaged in those circumstances? It's absolutely a developing area of law, but there are a number of health law authorities already in respect of Article 8, the right to private and family life, being engaged in those circumstances. First, looking at the domestic authorities, you have the case of Anifrea and London Borough of Southwark, an old case now, but still of some relevance. In that case, the three claimants were asylum seekers or refugees who had been unable to access benefits and advantages, including housing, because of the Secretary of State's maladministration. For example, there was a failure to provide accommodation for Anifrea. For N, one of the other claimants, there was inadequate financial support during his claim for asylum. And for M, the other claimant, there was a delay in him being able to obtain family reunion. In that case, the court held that maladministration can breach Article 8, where two circumstances are met. First, there is some element of culpability by a public authority, at the very least knowledge there was an interference in the individual's private and or family life. And second, there has to have been serious consequences or substantial prejudice to the individual's private and family life as a result of that maladministration. The other case to think about is Saeed from 2018. In that case, the defendants, as they were by the time it got to the Court of Appeal, were a family. They had experienced a 10-year delay in the processing of their applications for settlement. It was deemed by the court to be a manifestly excessive period of delay, and it took them little convincing to accept that their respective families' respective Article 8 rights were breached as a result of that delay. And that was looked at in particular at paragraph 153. The other case that Greg has already mentioned is the case of Hassan, again from the Court of Appeal this year, where a delay in providing the appellant with a biometric residence card was said to have wholly or substantially deprived him of his right to work, which arguably breached his right to private life, again in respect of Article 8. And there, the relevant paragraphs, I think, are 36 to 38 and 40. There are also Strasbourg authorities that are helpful on point, most of them perhaps in relation to the right to private life and how that interacts with employment. The first that I've cited is Nimitz in Germany, a very old case from 1992, where the court confirmed that Article 8 protects the right to develop relationships with others, including in the workplace. Sidabras in Lithuania from 2006, again, the court found that there was a far-reaching ban on taking up private sector employment affect the individual's private life, it was disproportionate and a breach of Article 8. Campagno in Italy, another fairly early case where the court found that any restriction on the right to seek employment must be justified under Article 8(2). Therefore, then it must be in accordance with the law, it must be necessary in the interests of national security, public safety, economic well-being of the country, etc. The other case, or the other case that followed, slightly newer, the Campagno and Kyriakis in Cyprus case, their private life was found to include the possibility to seek employment, and the right not to be arbitrarily deprived of employment opportunities in and of themselves. The case of Courage is slightly different. That concerned a number of applicants who were unable to regularize their resident status in Slovenia after the breakup of the former Republic of Yugoslavia. Some of them were stateless and others were citizens of post-Yugoslav states. In those circumstances, Article 8 again was engaged, both in respect to private and family life, and there was ultimately a violation found where the state failed to enable them to regularize their residence status over a sustained period of time. That line of thinking has been followed up more recently in the case of Sudeta and Hungary, where Strasbourg found a breach of Article 8 for a failure to provide an effective and accessible procedure to enable a stateless individual to regularize their stay, taking into account their private life interests. In that particular case, the applicant had tried to regularize their status in the third country, in Hungary, as a stateless person for a period of 15 years and ended up in a rather Kafkaesque situation where very little could be done. So, claiming damages for an ECHR violation of the Human Rights Act, the first point to bear in mind perhaps is the very short limitation period under Section 7.5 of the HRA. Their proceedings must be brought before the end of the period of 1 year, beginning with the date on which the complained act took place, or a longer period considered equitable, having regard to all of the circumstances. So the latter, the equitable, having regard to all of the circumstances, is a discretion that is broad by nature, as you can see from perhaps the two leading authorities, Dunn and Parole Board, and Roborn and Pennine Care NHS Foundation Trust. Citations are there for you. Just one word of caution, perhaps. The case of AP and Thameside is less than helpful in that respect, although I think it's fair to say that whether or not discretion is exercised in favour of extended time very much has to depend on the particular facts. I think in that case, the period of time that the applicant was out of time was 1.5 years, so a fairly significant period. The courts and tribunals have the power to award damages under Section 8 of the HRA, the judicial remedies provision. There, under Section 8.1, relief or a remedy can be granted where a public authority acts or proposes to act in a way that would be unlawful, where it is just and appropriate to do so. Under 8.2, Section 8.2, damages can be awarded where the court has power to do so. And as again we've seen in relation to Huson, that includes the upper tribunal under Section 16.2 of the Tribunals, Courts and Enforcement Act 2007. Awards for damages are not, however, made unless, under Section 8.3, taking into account all of the circumstances, including whether any relief has been granted, the consequences of the decision under challenge, and ultimately whether or not an award of damages is necessary to obtain just satisfaction. Those principles are distilled in the case of Greenford, which perhaps is well known, in 4 preliminary points. I don't intend to take you through them for the purposes of today, but it's worth having a look at. So claiming damages for ECHR violations really have to focus on whether or not damages should be awarded within the concept of just satisfaction, and that's provided for under Article 41 of the ECHR. Just satisfaction is essentially state compensation for the victim's loss and suffering. There are complications in figuring out whether or not it's appropriate to award it, not least because Strasbourg hasn't always been consistent on exactly when just satisfaction is required. The key principles have been outlined in some detail or summarised, 8 in total, by Mr. Justice Leggett, as he was then, in the case of Ahsan and the Ministry of Justice. Essentially, just touching on those very briefly, first, just satisfaction is not automatically awarded where there's been a violation of the convention right. Second, for financial compensation to be awarded, there must be a clear causal link between the damage claimed and the violation. Third, where there has been a financial pecuniary loss, the court will normally award the full amount of that loss as just satisfaction. Fourth, where an award is made for non-pecuniary loss, it's done so on an equitable basis, which includes consideration of whether the victim has suffered distress and anxiety, even if not recognized as psychiatric injury. Fifth, the purpose of the award is not punitive, but rather compensatory. Sixth, when deciding the level of award, the overall context of the breach has to be taken into account. Seventh, that may include the state's conduct, but similarly, that may also include the victim's conduct, which can reduce the amount of compensation below the actual damage sustained or prevent compensation altogether. So, looking at how to determine the actual figure for quantum, I think it's fair to say it's not straightforward by any stretch of the imagination. At least insofar as non-pecuniary loss is concerned, there are real difficulties in identifying exactly what it is likely to be worth. As I've already mentioned, the domestic route is through Section 8 of the HRA, and Section 8.4 in particular requires courts and tribunals to take into account the Strasbourg authorities. And as I've said, there is a systemic problem with that, which is that those authorities are neither consistent nor coherent and are not intended to have a precedential effect. There's further discussion from the case I just mentioned, the case of Ahsan, particularly at paragraph 923, but also the case of Pennington and the Parole Board. That's a 2010 case from the High Court, the Administrative Division, at paragraph 16 to 17, if you're interested, where there was a suggestion that the Strasbourg authorities should not be approached in a mathematical or mechanical way as a result. Another factor to bear in mind is that compensation awarded in Strasbourg has been considered for some time as ungenerous in comparison to English tort standards, considered exceedingly low and often merely symbolic in the case of Watkins in the House of Lords in 2006. In any event, there are also very few Strasbourg authorities addressing just satisfaction, specifically non-pecuniary loss, the type of circumstances that we're concerned with. It has to be, though, highly fact-sensitive in any event, and it's important to emphasize that awards of non-pecuniary loss are intensely fact-specific, and an absence of reported authorities on the types of scenarios that we're concerned with is problematic. Greg mentioned the Ahsan case. Really, that's authority for the principles that there could be a claim for damages under the HRA, but not actually the quantum, because of course that case was concerned with whether or not those arguments were arguable for the purposes of bringing a judicial review. Having said that, there are some authorities which give a general flavour of the often modest awards provided in respect to violations for Article 8, and they are of some use when looking at this. The first I've cited is Bernard and London Borough of Enfield. That involved damages where the claimants had been provided with manifestly unsuitable accommodation by the defendant, who had failed to discharge its statutory duty and make arrangements promptly for suitably adapted accommodation for the first claimant, who was severely disabled, and her husband, the second claimant. The unsuitable accommodation that they were provided was for a period of some 20 months. Ultimately, the court found that the claimants were subjected to a violation of their private and family life, although not a violation of Article 3, although it was a close call on the facts. The quantum of damages in respect of that Article 8 violation were addressed in some detail at paragraphs 42 to 58 of the judgment, but ultimately the claimants were awarded £10,000 in total, and that was made up of £8,000 for the first claimant and £2,000 for the second claimant. So a relatively modest sum, bearing in mind the ramifications of the violation. The other case that's worth thinking about is Medway Council, a family case. That concerned a mother and a child who were subject to ongoing care proceedings. The child was found to have been unlawfully removed from the mother, who was severely mentally unwell and lacked capacity, and then unlawfully accommodated by Medway Council for a period of 2 years and 3 months. There was also a breach of Article 6 ECHR, the right to a fair hearing, insofar as Medway had failed to initiate care proceedings in a proper and timely manner. The court looked at a number of factors when determining quantum, but ultimately found that damages to the value of £20,000 were to be awarded both to the mother and to her child separately. I've also mentioned I've also mentioned the two Strasbourg authorities, again, the case of Courage and the case of Sedita. In Courage, there was damages awarded, non-pecuniary just satisfaction damages of €20,000 to each of the 6 applicants. And in Sedita, a mere €8,000 was awarded in non-pecuniary damage. And remember, in that case, the victim had been unable to regularise his status for a period of 15 years. All of those figures have to be looked at with caution, significant caution, not least because, as I said, they are intensely fact-specific. And in relation to the Strasbourg authorities, non-pecuniary damages are set, taking into account the contracting state's circumstances as well, in particular their financial circumstances. Lastly, alternative remedies, question mark. Of course, in judicial review proceedings, when you're looking at whether or not a remedy really is an appropriate alternative remedy, you have to consider whether or not it's nowhere near as convenient, beneficial, and effectual as the claim for judicial review. 2 alternative routes have been raised in litigation. I think in relation to Ahsan, it was the Parliamentary and Health Service Ombudsman. There, the Secretary of State tried to argue that making a complaint to the Ombudsman was indeed an alternative remedy. Suffice to say, the Court of Appeal gave that very short shrift and rejected it at paragraph 62, but not with any detailed analysis. So I think it is worth very briefly looking at what the Ombudsman can and can't do. A summary of their role and powers is helpfully outlined on their own website. I think perhaps 2 points are worth bearing in mind. First, the Ombudsman cannot order the Home Office to pay compensation in the way that courts and tribunals can. And second, crucially, it cannot make the Home Office cancel or change the decision complained of. So there it's difficult to see how that can be realistically canvassed as an adequate alternative remedy. The other remedy I mentioned is the Home Office ex gratia scheme, and that's essentially outlined in its own policy. Again, you can find that on its website. It's the UK Visa and Immigration Financial Redress Guidance. It's worth looking at that policy in full, but essentially the ex gratia scheme allows for payment of a sum of money where there is no obligation or liability to pay for it in order to redress maladministration. Examples within the policy include where there's been a loss of documents, where there's been incorrectly addressed correspondence, the defacing and invalidating of documents, taking incorrect action, failing to respond to correspondence, and giving incorrect advice. Now, it's important to bear in mind that payment is entirely at the discretion of the Home Office. And crucially, the Home Office does not accept that delay constitutes maladministration. The other point to bear in mind is that the figures they suggest for ex gratia payments outlined in their guidance table are very, very, very modest indeed. For example, there's a suggestion that up to £1,000 can be awarded for the inability for a person to attend a dying relative's family funeral where documents have gone awry or where that has not been made possible because of maladministration. There they want to consider how close indeed that family member was before they determine how much to pay. The other example given is that £1,000 could be sufficient for incorrectly removing a person from the United Kingdom. So again, it's difficult to see how realistically that process can be considered a proper alternative remedy. Thank you very much.
So now you've had a pretty comprehensive overview of the potential additional remedies that you may have that can result not just in remedying the substantive immigration position, but actually securing compensatory damages for the kinds of harm that Greg and David have indicated, which can be really significant and consequential for your clients, both in terms of access to studies, to continue to study, to work, impact on mental health, all of those aspects of damage that can result in unlawful decisions taken by the Home Office can therefore, in principle, sound in damages. And what I was going to look at this stage, only by way of a brief overview, is the practice and procedure of how to vindicate these potential remedies. If we can just move on to the first slide, Amy, that would be great. So inevitably, the first question that you're going to ask yourself is, what's my correct forum? Is it to begin with by way of judicial review or a civil action? Plainly, if you require a mandatory order to prevent a removal or to challenge an existing and ongoing detention, then the claim will need to be issued in the upper tribunal or the administrative court so that you can obtain the mandatory remedies that are available in those forums. Even if your case does not require immediate remedies, if it has an important point of public law, then judicial review may still be the appropriate remedy. The case of Hossein that you've heard about, spoken by both Greg and David, made clear that judicial review is still an appropriate remedy if you're seeking declaratory relief in order to establish liability for damages. However, if none of these factors do arise in your case, then it would be necessary to issue in the QBD or the county court by way of a civil action. There are a number of factors that you take into account, but limitation would be an important one. So if it's a situation where you're beyond the 3 months time limit for judicial review, then you would be looking to bring your claim by way of civil action because of the more extended time limits. As you've heard, 6 years if it was a false imprisonment claim, 3 years if it's misfeasance or with a personal injury with power to extend. So if you are bringing your claim, if we go on to the next slide, by way of judicial review, then it's important when you issue the claim that you are cognizant of the fact that there may be a damages claim that you can make, even if you're immediately looking to secure remedies by way of preventing removal or release. And so you do have to be mindful of the fact that if there is a potential claim, you need to make it with your judicial review application. The case of BA and the Home Office, which was a Court of Appeal case in 2012, did proceed on the basis that a failure to plead a damages claim in an unlawful detention case and then bring it later by way of a civil action could constitute an abusive process. So you do have to be mindful of that at the outset. And it's also important the courts have increasingly emphasised the need to particularize your claim. The case of Fayed, relatively recent case, Lord Justice Singh emphasising the importance in the context of the Human Rights Act of pleading and particularising the claim. It isn't the same kind of pleading as you would if you'd begun it by way of a civil action, but it does require, as you'll see quoted there, that the principles that are applied by the European Court of Human Rights and under Article 41 of the Convention should be set out, and the heads of damages identified if it is pecuniary loss, loss of earnings, or humiliation and distress, sort of non-pecuniary damages that we're familiar with. So they do need to be articulated in your claim. If you're not in a position to do that, because A, of the urgency of the case, or because you simply don't have sufficient evidence at that point, then it's important to at least preserve your client's position by reserving the right to plead the damages claim, including on the basis of full disclosure. If you are in a position to sketch out the heads of damages at the outset or subsequently, then a schedule of damage is helpful. And of course, you need to be conscious that your client evidence should cover issues relating to loss and damage in order to found the case. The next issue then is the question of transfer. And if we could move to the next slide, Amy. This, I know, will be a feature of cases that we're all familiar with in when it concerns false imprisonment claims and unlawful detention, where there's a huge pressure, both coming from the respondent and from the court, to transfer detention claims once the substantive relief of release has been achieved. The rules relating to transfer from the High Court to the QBD or the County Court I've set out, and you can see them there. It's Practice Direction 7A under CPR 30. Whether it's the QBD or the County Court will depend on the value of the claim. So if it is a claim of more than £100,000, then it will have to be transferred to the QBD. If it's below 50, then it'll be the county court. But there are some other factors which you'll see set out at 2.4 that influence whether or not the case should remain in the QBD, in particular complexity and the importance of the issue. It is the case that a High Court judge sitting in the Queen's Bench Division, as with a county court judge, will have all the power and ability to determine the sorts of public law issues that will arise in these cases, and what can grant declaratory relief as well as damages. So there isn't any disadvantage in terms of a High Court judge in the QBD determining these claims. The upper tribunal, if we move on to the next slide, Amy, has different provisions. If you've had to start your case at the judicial review in the upper tribunal, then there's also power to transfer the case, and I've set out those provisions there, and the specific rule 33A applies if you're no longer seeking one of the public law remedies, then that will be a basis on which the case could be transferred from that court as well. So in overview, essentially, if you have achieved the relief you sought and all that you're really seeking now is declaratory relief in order to establish a claim for damages, then it's going to be hard to resist transfer. And certainly cases like the most recent one of ZA Pakistan emphasise very strongly previous cases that said that the administrative court should not be concerned with having to deal with damages claims. And although I know from practice that a lot of us feel much more comfortable with judicial review because it's where we have our vast experience in dealing with these kinds of cases, it has to be recognised, and it is fully set out in the ZA Pakistan case, that actually the civil courts do have very significant advantages over the judicial review court when it comes to determining questions of damage. Those include the fact that you do have more extensive disclosure obligations, you have a fact-finding function. A number of cases in judicial review, and ZA Pakistan was one of them, where there were factual disputes. They weren't resolved through cross-examination, and that led the court to accept the Secretary of State's versions of facts because there wasn't an ability to test the evidence. No one heard the individual give explanation. In that case, it was about whether they had disclosed a medical condition. And it also has to be said that in terms of developing areas of law, particularly the kinds of areas that Greg talked about with regards to negligence and misfeasance, you are going to get a better hearing and a more informed and competent judge to deal with those issues than you would in the Judicial Review Court. And aside from the legal elements of it, you've also obviously got the political aspect that I think we've all had the experience that judges of the Administrative Court in particular are less reluctant, are more reluctant to consider enforcing their judgments by way of damages. Doesn't sit comfortably with them, and there is, I think, an additional psychological burden that you have in the Administrative Court when it comes to actually establishing a right to damages as opposed to liability. So I think for all of those reasons, these cases may well be much better argued and more effectively and successfully argued in the civil courts. Of course, that does mean that you have to deal with the complex procedure rules and cost budgeting, which are very strongly enforced by the civil courts in a way that administrative courts have not traditionally and been much more flexible in terms of case management. And so you have to be able to deal with that aspect of the case, as well as the legal issues that arise. It is important to emphasize, however, that the Hussein case did make it clear that it wasn't a basis for refusing judicial review, the fact that the claim only concerned a declaration and damages. So whether it was in the right forum is one question, but whether or not the claim should still be pursued is a different question. And the Court of Appeal were clear that because there was an arguable claim for negligence arising from the public law errors in that case, it wasn't a case where permission could be rejected. So then moving on to the situation which Greg outlined, where you may have a detention claim, but also the potential for other forms of damages claims. These cases do present a challenge. It's obviously helpful if you have a context where there is an unlawful detention claim, because it is a well-established tort. There's well-established guidance on the damages that you get, but it does also mean that if you're adding to it a more speculative or difficult claim, you have to weigh up the tactical and practical consequences of running the two claims together, particularly cost implications. So it's very important when you're looking at your case to work out from the outset is to what extent can you establish that the damage to your client flowed from the detention. So an example of a case that I had was a woman who was unlawfully detained because a decision to refuse her Tier 2 application was not served on her. So the consequent decision to treat her as an overstayer and remove her and detain her was unlawful. She had a relatively short period of detention. It was about 2.5 months, but it did cause her to have significant psychiatric problems. And we had evidence that she was unable to work because of the consequences on her mental health. And so she was able to recover for the entire consequences of the delay in remedying her underlying immigration case, which took in total about 3 years. So she was unable to work for that entire period and recovered not only the substantial damages for loss of income, but also ongoing handicap in the labour market and disadvantage that she suffered from being out of employment. It's more complex if you have a period of detention which doesn't have those ongoing effects, but you have a separate decision, or the decision to prevent you from working, whether it's the revocation decision or wrongly treating you as an overstayer that prevents you from working, and it's that decision that causes the loss. In those circumstances, then obviously it's these other remedies that you may have, and you would have to work out the merits of that argument against the fact that you have a strong detention claim in weighing up cost risks. But the other side to that coin is that these cases do tend to have very short periods, or typically short periods of detention, but then followed by prolonged inability to work, crippling debt, and loss of earnings, and mental health problems arising from these prolonged situations of limbo in the hostile environment. And so those damages could be very much more substantial if you are able to establish it. So that's individual cases. What I want to just briefly talk about now is cases where you have common issues. And part of the reason for focusing on this particular topic was, as Greg has indicated, we have been all seeing very large numbers of cases with common issues where the Home Office has unlawfully taken action to revoke student visas, to revoke Tier 1 visas, to treat as overstayers. And they appear to be as a result of concerted general policy, which subsequently is seen to and identified and established to be unlawful. So they're not isolated cases. They are properly potential group litigation cases, and does give the opportunity to consider, if you had a significant number of cases, or across different firms there are a significant number of cases, whether it would be important to consider group litigation orders. In the context of the administrative court, if we just move on, Amy, to the next slide, there is in principle no there's no rule governing group litigation orders in the administrative court, but I've given you two examples where we were able to establish a group litigation type order in the context of a judicial review. The first case concerned challenges to the policies relating to disputed ages and decisions to detain. In the end, we had about 40 cases, all where the policy had been operated unlawfully and children had been wrongly detained when they were assessed improperly to be adults. That group litigation order, or the effect of it, meant that there was there was a resolution of the litigation in the end by consent, but it also meant that the claims for damages were also addressed together, and in fact a sum in the region of about £1 million was secured for those 40 children for relatively short periods of detention. The advantage of that was that some of them were only very short periods and may not on their own have crossed the threshold for public funding, but together we were able to litigate them effectively. Likewise, the second example was in the context of the DFT, where there were common issues arising amongst a large number of people. That allowed us again to bring to bear the fact that this was systemic failure, and resulted in concessions again, and ultimately contributed to the decision to suspend the fast track. That also then did lead to resolution of the damages claims, although not as successfully as the disputed children, because the government fought something of a rearguard action to resist that. But in principle, it was an effective tool for bringing together cases which raised common issues. So just moving then on to the rules that govern group litigation orders in the civil courts. It is, as I've indicated, a situation where you have a number of cases, and it can be simply more than two, which give rise to common or related issues of fact or law, which are described as the GLO issues. If we then move on to the order and what is covered by that, it's essentially a case management decision. The court identifies and agrees that there are common issues, establishes a register, and then cases that do raise those same issues can be placed on the group register. Common issues are and legal issues are identified, and test cases are selected. If we then move on to the final slide, 19.12 sets out what the effect of a group litigation order is, and it's essentially that all those cases that are on the register will be bound by the judgment of the court on the common factual or legal issues, and so that they can all benefit from the order that is made and the judgment that is made, and also can share costs, which again, if you had a significant number of cases, may be of advantage, both in terms of obtaining legal aid, or if you have clients who you may be under a CFA, then you may be able to cost share. So that's something to think about if we do find ourselves in a situation which we hope this seminar triggers or contributes to, where there are collections of cases that are brought together that raise these important questions about the practices of the Home Office and whether they do constitute a general illegality to which significant numbers of people have been affected. And then, of course, the question of whether and to what extent there are tortious or human rights damages that flow from it. And we're very keen to see if there is a way in which concerted action can be taken to pursue these sorts of cases in the future. So those are all the observations I was going to make on practice and procedure. We're running a little bit over time, but if there are any questions, then this is an opportunity to ask them. I can't see that there's any specific questions in the chat, save for one question that's been raised about revocation of ILR without a right of appeal. And that situation would certainly fall within the category of cases that we've been considering. If the revocation was unlawful, that would be established by way of judicial review as the only remedy that's available. Then it could potentially give rise to a claim for damages under the common law torts that you've heard, depending on the facts, or certainly human rights damages if the consequences are to infringe your fundamental rights by reference to the sorts of factors we've addressed: the hostile environment, impact on mental health, impact on family life rights. So yes, in principle, there's no reason why the decision, if it is a revocation of ILR, all of these matters wouldn't potentially apply to that category of case as it would to revocation of a student visa or tier 1 or other employment related right to remain.
I was just going to raise one thing, which is that there is another category of cases we haven't covered, which is in relation to people who were kept apart, but as a result of the Home Office's unlawful operation of Dublin regulation. So people who should have been united under the regulation and weren't. There are a series of cases on that. I'm doing one with Sonali in relation to a child who was unlawfully separated from his uncle in the UK and unlawfully removed. But there is a line of authorities, I don't think any of them are actually reported as yet, dealing with damages in circumstances where people were unlawfully kept apart. Actually, one of them might be reported, but the president of the tribunal, Mr. Justice Lane, is considering a case in the tribunal in the next month or so, and that is going to give some guidance, I think, on what the upper tribunal's approach to damages is. Because there's been, obviously, Stephanie spoke about the fact that the county court's better placed to deal with most of these damages questions, and typically the issue of damages is transferred. But there have been cases where the upper tribunal has looked at the question of damages itself. Sometimes, certainly in the case I'm doing it, the Secretary of State's insistence. So I think we'll get some more clarity soon what the approach of the upper tribunal to those issues is going to be.
The other point is that the upper tribunal could theoretically look at liability and then transfer quantum to the county court or the QBD. Both courts obviously much more knowledgeable, much more experienced in those assessments.
And that's what we expected to happen in our case, but in the end we had to continue it in the upper tribunal, because the upper tribunal does have the power to do it because of the effect of the TCAA. But obviously the county court's a much better place to make those kinds of decisions.
Just one other observation on the question about revocation of ILR. I think some of the authorities I've focused on really look at maladministration and whether or not that constitutes a violation of Article 8. Less clear whether or not a decision that was simply wrong subsequently is in the same category. Although Steph's point is right, if you can show that there is an interference, a disproportionate interference in your Article 8 rights, private and family rights, from the hostile environment and the prohibition to work, maybe the maladministration point is unnecessary anyway. Maybe all you need is to show that harm, and damages, at least on the HRA, should follow.
Yeah, I agree with that. There is a question in the chat about someone who's been waiting over a year after a successful appeal. I think that you've got a very clear case there for judicial review in terms of the delay. The case of Demakaya is Denez. Someone will correct me. The Duran's case is from some time ago, Denez. Which established Lord Justice Elias that failure to grant status following a successful appeal of that sort of magnitude is unlawful, and not just maladministration. And if the client is suffering as a result of that in terms of access to benefits or other consequences, then in principle you would also have a claim for damages. So I would be issuing a letter before action, I think, probably not just a formal complaint. Yes, sorry, that's the one. Thank you, Jawed. That's it, Dead Mersin, of course. Thank you. So unless there are any follow-up questions, I think that brings this seminar to a close. Thank you all for participating, and I wish you all the best in not only assisting your clients to stay in the country or be released, but also to achieve some compensation for some of the very serious harm that is caused by fundamental failures in Home Office practice and policy. Thank you.
Hi there, we have one more question from a phone caller from Sikandar. So I'll just allow him to talk, or has talk, and then answer that way.
Hi there, good afternoon.
Hello.
Hi there. Yes, my name is Tahir Khan. I am Sikandar's colleague. We are watching together this seminar. I have been dealing with a lot of TOIEC revocation or curtailment letter issues for some time. I obviously followed at the time of Ahsan and others, and some college cases as well, as you could remember from the BBC Panorama program, if you recall. Now, there are a lot of students, obviously there was about 40 to 50,000 students who were either sent back home packing without looking at their ATS results, or properly without any due diligence. And then there was a case of Ahsan and others. Then Balajigari came 3325. So all of these have been following. I have already represented a uni as well. Now I have got a couple of inquiries from abroad, which the students are still feeling they have been hard done by. They appeared themselves, and they have all the plausible explanation. And about 90% cases I have won so far, which have been taken to court, tribunal, and some of them Home Office are giving them 30 months human rights leave, which is again wrong when they qualify for 10-year lawful residence, because 3C leave has been continued because of the Home Office unlawful decision at the time, which they have reversed after 4, 5, 6 years. Now, what would happen to those students who have been unable to study all these years? Is there a classic GLO case we can take it further to court for damages?
Greg, do you want to deal with that on the substance? I know you've been dealing with a lot of.
Yeah. So there's on the point about 2.5 years instead of 10 years. If you have been here for 10 years and a chunk of that was unlawful because of your leave being curtailed and it shouldn't have been,
Yeah.
then you should be able to get ILR, and I have been able to do that in a number of cases. I think we've had 2 JRs on it, but they do tend to accept that as long as you meet the other requirements for ILR.
Yes.
As to whether or not there's a basis for challenging decisions on TOIEC, I think there is. I think there are a number of people who are looking at it at the moment. There are lots of different clients. It will depend on the fact, I think, whether or not your client has a decent case for it. But I think a lot of people do. I mean, in the cases that I'm doing, I'm generally arguing misfeasance and I'm arguing breach of Article 8, most of them.
Thank you so much. I think you've answered my question. I will be in touch after the
Yeah.
what's wrong with the number of cases I have. Thank you.
Yeah, I think that's certainly the category of case in which we had been thinking there was the potential for bringing together cases potentially under a group litigation type order.
That's correct. I think that looks the case where we are. Thank you so much. Thanks for your time, and thanks for your listening to me and giving me a chance to ask this question.
No, you're welcome. And just to say that the Mersin case has been put into the chat room. That's the one about delay after status after a successful appeal. So you can have that, and you will also all get the slides following on from the webinar.
Sure. And asylum undue delay cases, I've been advancing a couple of them on public law and taking them to court, but they are coming back and back and forth. Although I have explained their rationale that they have been 2 years, no interview dates, and they are unable to do any job, any employment. And then there is one particular in asylum under the Geneva Convention, which I am thinking this is a legal point to take forward, is there are specific areas of employment they can work in rather than they are allowed all along. So that is something needs to be taken as a legal point, because a lot of refugees, there are disadvantages to have the education, let alone expertise in specific area. So that is something I would like to advance public law matters as well. I have taken, but I'm getting it hammered back. But I might be in touch with you on that as well.
Okay.
Thank you so much.
Can we also put a couple of slides?
Yeah.
Okay. Well, I think that probably was the last question that we had. So thank you for joining, and good luck for any future cases that you bring.
Thanks very much, everyone. Bye-bye.